All right, folks, we're going to go ahead and get started. If you could please make your way back in and find your seats. Welcome back. Our fifth speaker today is Professor Lee Ford Tritt. Professor Tritt received his JD from NYU School of Law along with an LLM in taxation. He is a law professor and member of the graduate tax faculty at the University of Florida College of Law. In addition, Professor Tritt is director of the Center for Estate Planning and director of the Estate Planning Practice Certificate Program. His strong commitment to students and in the practice of law has helped him earn Professor of the Year 5 times. In addition, he received the University of Florida's Presidential Award for Excellence in Education in 2011 and the University of Florida's Impact Award in 2012. Professor Tritt is a fellow of the American College of Trust and Estate Counsel and the vice president of the American Association of Law Schools Trust and Estate Division. In addition, Professor Tritt serves as the vice chair of the ABA Real Property Trust and Estate Law Section's Outreach Committee, as well as chair of the Committee for the Non-Tax Estate Planning Considerations Group. He is also an advisor for the Committee on an Act on the Recovery of Stolen Cultural and Artistic Property for the National Conference of Commissioners on Uniform State Laws. Today, Professor Tritt will be presenting on Dispatches from the Trenches of America's Great Gun Trust Wars. Please help me welcome to the stage Professor Lee Ford Tritt.
Oh, you okay? Thank you so much. I'm psyched to be here. I'm Lee Ford Tritt from the University of Florida. First, I want to just talk about Brent, who just spoke. I was initially very excited to follow a student when I was told I was speaking today, and he did such a great job. I'm now kind of irritated that I'm following him. I wish I'm following like a tax professor or a tax lawyer. That would be much better. And Brent, I guess if you can say shit out of luck, I can say kick ass. You did a good job. I noticed that Brent's already a professional because he spoke and he's left. So he's like, I'm not listening to the rest of y'all. Second, the journal. Thank you so much for inviting me. I am so psyched. I've been so jealous for so many years. I've never been invited to this. It has irritated me when I hear Nancy or Bill Lapiena talk about this, what a great show you run. Thank you so much for inviting me. Third, Hayden. I wanted to thank you for picking me up at the airport, driving me around. He's been my chauffeur and my host. He's been wonderful. When he heard I was speaking on gun trust, he's like, this is the perfect campus for gun trust. He goes, because we have something called Guns Up. And it was great because he was trying to teach me how to do Guns Up. And I was like, how do you do it? And he's like, listen, you're not Sarah Palin. It's not like that. You have to have it up and it's weird. And finally he just looked at me exasperated and he goes, I hope you're a better lecturer than you are a student. And Hayden, I can't promise you that. You might be just as frustrated. Listen, in January of, let me see if I can do technology. It's not always my strength. In January of 2016, last winter, I was so psyched. I'd written a book on gun trust and firearms, and I got the first copy, literally the first hard copy from the publisher. I called up my mom and dad. I'm like, hey, great book. And within 30 minutes, new regulations were announced that were going to be enacted over summer, in July of 2016. That changed everything. And I went from being really psyched to being irrelevant in 30 minutes. It wasn't very much fun. And all my friends and professors and lawyers were calling me up and saying, hey, gun trusts are dead. What are you going to do now? The death of gun trust. And let me say, this death of gun trust has been greatly exaggerated. First, it gives me a chance to do a second edition, which is pretty good. Since my dad is the only one who bought the first edition, maybe the second one will go better. But more importantly, the gun trusts are something important, and they're still very relevant for two reasons, and it's both the essential nature of gun trust. First, gun trusts provide great estate planning opportunities. And second, gun trusts still allow your clients to take advantage and massage and find some flexibility in federal gun laws. So, I know we're not all on the same level playing field yet, so let's get us together. Let me put us that we all know what we're talking about. What I'm going to do today, here's my little roadmap. I'm going to go over basically what firearms are, and explain the difference between the NFA firearms and non-NFA firearms. I'm going to talk about the weapons. I'm going to talk about what gun trusts are and our new regulations over summer, the ATF Rule 41F, which does change the landscape of gun trust. We're going to play with some drafting considerations if we have time. And finally, I'm going to compare why you still want to use gun trust versus individual purchases or a corporation LLC doing this. So let's play. I think this is going to be pretty fun. The categories of gun trust. Well, the Gun Control Act of 1968, it was enacted as a means to restrict the transfers of certain types of firearms, some serious firearms, between individuals, business entities, and trust. And so we know what we're talking about. You hear lots of terms used for gun trust and for firearms. And the first term is Title I. These are also called non-NFA firearms. And these are typical firearms. These are long guns, our shotguns, your Glock, your handguns, things like that. The second category of firearms are called Title II firearms, or NFA firearms. And these are more serious firearms. These are going to be machine guns, short-barreled rifles, and suppressors, bombs, tanks, things like that. When I first gave this lecture, I mentioned and I once referred to something called Class III firearms. And I was quickly, when you talk about guns, you got to get up to speed, especially in the South. And so I don't want you to be uncool and never refer to Title II or NFA firearms as Class III firearms. Your clients won't respect you. Class III firearms is a misnomer. Those are for merchants. They categorize merchants who can sell Title II firearms or NFA firearms. So here's our big terms, Title I, Title II, or we can call them non-NFA and NFA. First, I want to just discuss in general estate planning for non-serious firearms, or Title I, or non-NFA firearms. So why do we even care about this? Well, this is an amazing thing. 43% of Americans own firearms. They keep firearms in their home. And we have over 250,000 machine guns and other NFA weapons. When I was an estate planner, I don't think I ever asked my clients if they own firearms. And if I knew about the serious implications concerning firearms, I would. Now, it's interesting. If this many Americans own firearms, it's strange that we don't ask about this. And they could own them in different ways. They might have a collection that they inherited from a father or grandfather. They might not even consider certain things firearms. And I've talked to lawyers who talk to their clients about firearms. And I said, hey, do you put that in your questionnaire? And they told me no, they don't like to put it in their questionnaires because people who own firearms typically are very private and they don't want to discuss things, they don't want to put things in writing. So I think it's something that you need to start asking your clients about and talking to them about firearms, especially since there's so much ownership of them. Now, when we're talking about estate planning for non-NFA firearms, or revolvers, or pistols, or rifles, or shotguns, there's some interesting things I think you still need to do. I think, one, you need to really think about how the beneficiaries are going to be able to possess these. You have to look at state law. You have to look at county laws. State and county laws change. They have restrictions on what type of beneficiaries can hold these. Beneficiaries typically can't be over 18. They can't be convicted of a felony. Typically, most states have about 10 categories, similar to the federal categories, that would disqualify somebody from owning this. I think this is something you would want to work into your wills, but more importantly, trust. Even for non-NFA firearms, I think trusts are still the way to go, a separate trust to hold firearms. I think you want to conduct background checks on intended beneficiaries, especially if you're going to put a personal representative or an executor or a trustee in the line of fire for distributing firearms. They will be personally responsible for distribution of firearms from making an illegal transfer if these beneficiaries aren't qualified. So you don't want to do that to your PR, your executor. I'm sorry, they call them personal representatives in Florida. Executors are your trustees. I think you always want to name alternative beneficiaries. You always want to have backups, just in case somebody's not qualified. And you want your wills and trusts to literally talk about the qualifications. Talk about what type of firearms. You need to have somebody know where they're located. You need to have backups. You need to talk about the state laws and the federal laws in these instruments. So that's our non-NFA firearms. Let's talk about the NFA firearms. And what the hell is NFA? See, I didn't know y'all could cuss down here, but like Brent is like, woo! I'm even going to unbutton my jacket because I didn't know y'all were so casual here. So our National Firearms Law. The National Firearms Act of 1934, this is the big thing where we get NFA from. This was our federal government's first attempt to regulate and control these types of lethal firearms. This was during Prohibition. This was the gangsters' days with the machine guns going around, and the government was very nervous. And they did this through the taxing authority. You might say, Tritt, why the hell do you know about this sort of stuff? Well, this is all in the tax code, right? The NFA law. So, it's a tax thing. They put a $200 tax for the purchase or transfer or manufacture of certain types of guns, firearms. Interestingly, they didn't adjust it for inflation. So way back then, $200 might have been prohibitive of certain people buying these types of guns. Realize today, the $200 tax stamp you have to buy to transfer these types of firearms is not very much. So it doesn't really have that effect. It mandates that any person must register their firearms with the Bureau of Alcohol, Tobacco, and Firearms. So you have to do it through the ATF. When they mean persons, there's three types of persons. There's individuals, there's trust, and then there's business entities. So all three types of entities. And this gives us some gamemanship. This gives us a play. So when your client comes to you and they want to purchase one of these types of firearms, you need to think about it. Are we going to do it individually? We're going to create a gun trust? Are we going to create a corporation, an LLC? And I think gun trusts are probably the best way to go. Under this law, it is illegal for anyone other than the registered owner to possess the NFA firearm. And I think this is very important today of why you still want to use a trust form, and we'll talk about it. But realize, only the legal registered owner can possess an NFA firearm. I'm going to jump a little bit out of order for a second. But the National Firearms Act, what they do is they say we regulate especially dangerous weapons, and it's going to govern the purchase, the sale, the transfer, the ownership, the use, and the possession of these types of weapons, and also the manufacturing. And a lot of my lawyers that will talk to me, they'll say, we don't have clients that manufacture Title II firearms. Are you crazy? Realize manufacturing is pretty easy. If I take my shotgun and I shorten the barrel, I've manufactured an NFA firearm. So your clients could be manufacturing NFA firearms. So they did this. Now, listen, there's another type of law that came about, and this is the Gun Control Act of 1963. And the Gun Control Act of 1963, as opposed to going through the tax code, it went through Congress's power to regulate interstate commerce, and it created some criminal acts. And what the Gun Control Act does is it takes the old National Firearms Act, the NFA, and they shove it under the code under something called Title I and Title II. And that's why we get two different sets of names. There's really no NFA anymore. There's no National Firearms Act anymore. It's incorporated into our new act under Title I and Title II, the Gun Control Act. And that's why some people call them Title I guns and Title II guns, and some people call them National NFA guns and non-NFA guns. There is one other type of law I want to talk about. In 1986, the Firearms Owners Protection Act came through, and they created something called the Hughes Amendment. And the Hughes Amendment did two sort of things. One, it said, listen, individuals cannot purchase any machine guns after 1986 that have been manufactured after 1986. But government entities and police can. What this did is this just created a very sharp and false market on machine guns, especially M16s. M16s now cost $25,000 to $30,000 to buy because there's such a limited quantity, when governments and police typically will buy them for under $1,000. So it's a very high market. The Firearms Protection Act also did something else. It created a safe harbor for passage. I often hear lawyers say, be careful, it's illegal to transfer firearms from state to state. That's not necessarily the case. There's a safe passage under this act that said as long as you're going from a state where you can legally possess it to a state where you can legally possess it, you can do it. You might have to notify ATF. You have to keep the weapons unloaded and in a distance from you that you can't access them. But we'll talk about more of these provisions. So that's kind of the gun laws that kind of came about. When we're talking about our NFA Title II weapons, what are they? What are they specifically? Well, by the way, this really is a picture of a pink machine gun. First of all, they're machine guns. This is the typical one, weapons that can be fired automatically. All our automatic guns are considered machine guns. Anything that will fire more than one shot without reloading is going to be our machine guns. There are also going to be parts that can convert a semi-automatic weapon into an automatic weapon. So realize you could manufacture an NFA firearm pretty easily. We're going to talk about short-barreled shotguns and rifles. Don't call them sawed-off shotguns. I did that once, and half the audience screamed at me. I was at a gun convention, and they're like, "No, they're short-barrel." So our short-barreled shotguns and rifles are NFA firearms. Suppressors and silencers are NFA firearms. You would have to regulate that. I think the cool stuff is any other destructive. Now, I have to say, we've talked about all these cool things. I mean, it can be a hand grenade, it can be, these bombs, it can be tanks. If you go on YouTube, it's amazing what people will buy and film themselves destroying through these type of devices. And then we have like our cool little devices like our spy stuff, like our hidden weapons, our pin guns, and things like that. All of these are NFA weapons. And realize there's actually a collector's market for this. So a lot of people who aren't even into firearms, they have collecting of these type of firearms. Now, it is illegal to make or transfer an NFA firearm unless you do one of, well, basically two forms, a Form 1 or a Form 4. We'll talk about what these forms are. There's also a Form 5 that we'll talk about. Some states and local governments impose additional legal restrictions or prohibit ownership of NFA firearms. So for instance, New York and California, just because the federal government lets you buy it, those states do not let you possess them in their states. So you will not be able to, even through a gun trust, be able to possess in those states. When they're talking about transferring, what do they mean by this transfer, this tax that you have to buy, this $200 tax? Well, it's selling, assigning, pledging, leasing, loaning, giving away, or otherwise disposing of any of these national firearm weapons. So realize it's very broad, and this means bequeathing and giving in our world. And so if you want to transfer an NFA firearm, you have to fill out a certain form and pay your $200 stamp tax. The forms that I think are most important for us are Forms 4 and 5. One is for manufacturing, which some of your clients might deal with if they're going to make their own firearms. But 4 is a person-to-person or dealer-to-dealer or anything like that. If somebody wants to purchase an NFA firearm, they're going to have to pay for their $200 stamp tax and apply for Form 4. Form 5 is important for us because this is the transfer through an estate. And you do not have to pay the $200 stamp tax here. You can transfer it without the $200 tax stamp. And I think there's an interesting new problem with Form 5 since our new regulations that we'll talk about later on. How popular are these? Well, look at our 2012. In 2012, under Form 4, people who were purchasing just NFA firearms, we have, through gun trust, we have almost 36,000. We have 35,200 people who bought individual, 25,000 in that year. I looked at 2013. We had almost 60,000 applications for Title II guns through gun trust. That came up from 2003, only 45 applications. Wow, that's amazing, the use of these gun trusts. Why are gun trusts, why have they escalated so much in these applications? I think really And I think you probably know clients like this. Every time an administration talks about new gun regulations or new gun laws, two types of industries are advertised amazingly. The gun industry will advertise saying, come and buy our weapons, buy the bullets now. The other type is actually trust and estates lawyers. I see so much advertisement saying, get your gun trust now. Get your gun trust now and put in the gun trust, because if they ever change the law, you're protected. It's in a trust. And I see lots of advertising for gun trusts, especially in certain states. It's a big industry. So we know that a lot of people are applying. You have to fill out this form. You cannot be a prohibited person. Prohibited persons, I think it's an interesting category, and most states replicate this. So let's think about it. You can't transfer to a prohibited person. Let's say you're a PR, and the estate has NFA firearms. How often do you know when you're making distributions to beneficiaries, do you know if they've ever smoked pot? A lot of lawyers say, listen, it says addicted to a controlled substance, but C doesn't. It says any unlawful user of a controlled substance. Realize if a PR turned that gun over somebody who smoked pot, you've just committed a felony. Look at this list of prohibited people. It's very important to keep track of this. So, I have to say, I never ask these sort of questions, and in fact, sometimes I don't even know if firearms are in the estate when I'm working with a PR and making distributions. Well, you might say, what's the big deal if we actually do that transfer? If you're serving as a beneficiary, a trustee, a PR or a trustee, well, it's not too bad. It's only 10 years in prison, $250,000 in fine. The weapon gets forfeited, and any vehicle used to convey that weapon, so if you took it over in your car to the beneficiary, your car's gone. So this is some pretty serious stuff. You don't want to play with this stuff. Now, possession of a weapon, I told you, only the owner may possess. Innocent possession is in violation of the federal law. Although there's a 3-year statute of limitations, it doesn't start to run until you're no longer illegally possessing it. And constructive possession is in violation of the federal law. And actually, I think this is the way our clients get in the most trouble. They don't realize what constructive possession is. And this is interesting. Constructive possession is anybody else, other than the actual registered owner, having the ability to access the firearm. So let's think about this. Your client, she owns a machine gun. She keeps it in her gun safe. She thinks she's being very safe about this, right? She puts it in her gun safe. Her husband knows the combination of the gun safe. He's in constructive possession. He's breaking the law. He's committing a felony. If she doesn't keep it in the gun safe and her children or anybody else have access to it, anytime somebody walks into the house, constructive possession. It's very serious. This is one of the main reasons why I think you should still have gun trust, and we'll talk about this sort of thing. If you die with no planning, the very first thing, if you don't have gun trust and your client dies, lawyers, executors, you need to determine if the weapon was ever registered, if the firearm was registered. If it wasn't registered, listen, you got to contact the ATF ASAP. You don't touch that weapon. You don't take that weapon anywhere. You don't take it to a safe place. I hear PR executors and lawyers all the time saying, well, I took it to a gun shop for safekeeping. You just transferred a Title II firearm and you're not the registered owner. Sometimes they say, I took it for appraisal. I took it to be cleaned. No, don't do it. Listen, contact. How about if it is registered? Well, listen, even if it is a registered NFA firearm, you're not the registered owner. You're not the registered owner. So I think even if you're going to have to contact the ATF, you don't want to move anything. There's a new rule for executors, which is going to help us out here. But I think you want to make sure that none of your clients' families or friends are going to be accidentally deemed as a constructive owner. Now, let's move on to actual gun trust, what we're supposed to talk about. Right? Yeah. Oh, no. Yeah. Okay. So gun trust, guns up. Listen, what are gun trusts? Let me start about what gun trusts aren't, because gun trusts get a lot of bad press. Gun trusts aren't illegal. They don't exploit a loophole in the federal law. The federal law actually envisions trust owning these, and they spell out exactly how trust should own them. It does not provide a means to purchase illegal firearms. The laws don't change. The trust cannot buy an illegal firearm like an individual. In fact, if you think about it, if someone's going to take the trouble to go to a lawyer to create a gun trust, register with the federal government, they're typically not buying illegal firearms. They are no party associated with the trust. The settlor, the trustee, or beneficiaries are insulated from any criminal liability. They're all subject to criminal liability like individuals are. And finally, using a trust does not get you out of like these cooling off periods or these wait periods. So gun trust doesn't do all that. But what gun trusts do? Well, listen, you're going to create a trust like we do for any type of other things. We create specialty trust all the time to hold life insurance, to hold houses, cuprids, eyelets. But this is going to hold guns, and it's going to have special provisions for guns. It's going to buy the guns. And through the process, we're going to fill out our forms and follow our NFA rules. Now, over summer, there was a new rule that came out. Now, why did people use gun trust to begin with? I'm going to kind of play off the slides. We won't follow them directly. Well, let's think about this. Before the ATF had rules transferring NFA firearms, and they hadn't changed for 50 years. And there were different requirements for individuals to purchase them than trust. And some of them just made sense. Individuals, and we'll talk about this in a little bit, but individuals had to give a photo, a fingerprint for background checks. Individuals had to go and get a chief law enforcement signature done for the application process. Trust didn't. You can't fingerprint a trust. You can't take a picture of a trust. And trust didn't have to get this chief law enforcement officer signature. But also, there were some other things that the trust applies continuity for estate planning purposes. So I think that was important. July 13th, 2016, not retroactive, we have new rules coming out. New rules came out. Now, the process before this new rule, well, the purchase of a firearm, you have to make sure the CLE, the chief law enforcement officer will approve your purchase. You had to do the ATF form. You had to pay your $200 tax. You had to do fingerprints. And there was a long wait. What was the problem? Well, a lot of chief law enforcement officers blanketly refused to sign these forms. They just didn't, depending on the area. Florida had no problem, Tennessee had no problem, but up north, a lot of chief law enforcement officers didn't. And when we started doing research, we were trying to figure out why they didn't do it. It was for several reasons. One, they just didn't want these type of weapons in their area. Two, they were worried if they signed off on it, somehow they would be liable if there was some sort of catastrophe that happened with it. And three, we actually picked up on some racism and economic problems. That sometimes they gave it to very wealthy white individuals, and they wouldn't give it to poor people or people of color, these signatures. Now, if you used a trust, you can purchase a firearm, you have to do the ATF form, you pay your $200 tax, you send your copy of the trust, which would remain quiet. It really wasn't a longer wait. It was a much shorter wait, I should say short wait, for stamp approval. But realize I did not have to get the chief law enforcement officer to sign off on it. And I didn't have to submit any fingerprints, background checks, or anything like that. So a lot of people started using gun trust. In addition, that was one reason they used it. The other reason they used it is there is a legit estate planning issues. I want to put in there, PR, be careful, executive, be careful. Beneficiaries can't be these, put conditions on beneficiaries. There was a lot. The new rule, well, it changed the chief law enforcer for individuals. It said, listen, you just have to notify it. Well, that was better for the individuals. For trust, they said, well, you just have to notify the chief law enforcement officer. And by notify, you don't have to send them very much. You just have to literally notify them. It's easy. But they did add something. They said for each responsible person, they have to turn in fingerprints and a photo. They tried to match it up. And this is why everybody said, gun trusts are over. They're dead. Because now individuals don't have to do CLEO, get permission, and now responsible persons do. And what's a responsible person? Well, it's a trustee, right? It's the trustee. Now, people are saying, this is dead. I want to get through. Okay. So, our new CLEO notifications. Well, our new CLEO notifications are pretty simple. You just complete the forms. You mail in your forms. You mail in the fingerprints. You mail in all that to the ATF. But to your chief law enforcement officer, you just send a notification. You don't send fingerprints. You don't send photos. You don't do anything like that. So that's kind of played out nicely. Who's a responsible person? Any person who has the power or authority to direct the management and the policies of the trust. Responsible people in corporations would be the managers of the corporations, the officers, people who have access to the firearms in the corporations, if you had to do this. There is a certain issue that has come up, and I don't know, Professor Bayer, if you know this yet, the answer to this. So under Form 1, when you manufacture, you have to do all this. You have to turn in your fingerprint, you have to do all this. Under Form 4, trust, LLCs, individuals, have to turn in all these. But Form 5, which is for probate, which doesn't give the $200 tax, it does not say that you have to turn in fingerprints or photos or get CLEO notification. And that seems to be a glaring mistake. Now, ATF said, listen, they might enforce that. I know a lot of gun lawyers who say, we'll challenge that. And realize to change the regulations, it usually takes 4 to 5 years to change the regulations. So there is this weird disparity between the forms, and I don't know how the forms are going to play out. Before we start talking about the drafting issues, when we're talking about gun trust, people will say, well, Tritt, why do we want to do gun trust anymore now if it's all if it seems to be level playing field? Well, first of all, I still want to say, I'm sorry, and the new rule also says, listen, PRs get immunity that if you become an executive of an estate that has NFA firearms, we will deem you to be sort of registered, and we'll give you a wink pass, to possess these firearms. But that doesn't mean family members and stuff like that. So why do you want to still do a trust? Well, there's still estate planning issues, right? You want to keep it in trust for continuity. You want to be able to put all these provisions in there that say who you can transfer it to, why, what are the prohibitions. You want to make sure that none of your family members are constructive possessors of it, so now the trust will own it. So there's a lot of reasons why you want to keep it in trust for an estate planning point of view. Why would you want to put it in trust for the non-estate planning point of view? Well, one thing is if gun laws change, these firearms are protected in the trust. We know that they don't do retroactive applications when they do these, so your trust would still do this. Realize also if individuals own it, every time you transfer it to your grown children, or you have an estate, or you want to give it as a gift, you go through a new transfer process. Trust, you don't, right? We have continuous ownership. This is important because here's the catch. The rule says only the initial responsible person has to register. So that's just the initial trustee. The second registration's over, you can switch trustees, you can change trustees, you can do whatever you want. Total privacy, no turning in fingerprints, no turning in photos, no CLEO, Chief Law Enforcement Officer notification. You can do that. The second, I think the biggest reasons why your clients would want to do it is think about your clients who own these type of firearms. What do they really want to do? They want to take their buddies down to the shooting range, don't they? And use them and let their buddies use them. The law says only the owner can have possession of this. But the trust is the owner. And literally the trust allows you to appoint temporary trustees. This is some of the language you'll put in that. So I can put my spouse in, I can put my adult children in, as long as they're not prohibited people. I can put anybody in here. If we want to go down to the firing range with my machine gun, I don't own a machine gun, but if we did, I could put you in as a temporary trustee, and now you can have possession and fire this. And this is really one of the major reasons why firearm owners want to have these type of gun trusts. So there's a lot of serious reasons why gun trusts are still around. Now, I know this makes some types of, I don't want to get into the Second Amendment or whether people should own firearms or not, but people who own firearms, these things are very important to them when they're thinking about it. So drafting considerations, I think, are pretty important when you're thinking about them. Typically, they're going to be revocable trusts that you're going to put your firearms in because, your owner was going to want to put them in. These trusts are not really meant for beneficiaries. These trusts are not really meant for beneficiaries. These trusts are meant for trustees to use the weapon. So there's interesting things when we think about our typical trust. You need to put in a lot of clauses about what happens if somebody's a prohibited person. You need to put in clauses about being able to appoint temporary trustees and things like that. Typically, I see them perpetual or as long as the rule of against perpetuities would allow, because you don't want them ever coming out of trust, being subjected to new transfer laws. So I see a lot of interesting trust things. Somebody recently said, well, listen, why don't we do it through a corporation instead of a trust versus an individual? We can still do all three. I typically think a corporation is a bad form to do it because, one, you have public filings. Two, unlike the trust, if you create a corporation just to own firearms, you have to pay your yearly fees, you have to register your corporation or your LLC. There's a lot of documents that you have to do. I think the costs are greater and you don't have the flexibility of the gun trust. I still know a lot of individuals who own it outright, but I have to tell you, a lot of the people who buy these type of weapons, they actually want some to be anonymous. They want some privacy, so trusts work for them as well. As far as like the popularity of gun trusts, I've been shocked how popular they are. I have been shocked at even like the big trust production, do-it-yourself trust like Logic and these other big trust production company computer programs. They now have gun trust on there. I do think it's a problem though that people draft gun trusts pretty poorly. I was talking to a person at ATF. This is a true story. And I actually went to test this theory out. He says most people just download a form. And it's a poorly done form. It doesn't have all the great provisions you need to do. And he also says gun sellers will have this form there. And I went to, in Gainesville, Florida, I went to the gun seller. I said, I wanted to buy a Title II gun. And he's like, oh, don't buy it individually. Here's a trust. And he handed me a copy of a trust. And it's the exact trust the ATF officer told me about. It is an identical trust, and he says he gets thousands a year. And it has this poor woman in Kansas City as the beneficiary. Because they're all concerned about who's the trustee. And they have like this woman in Kansas City who's ultimately going to get tens of thousands of firearms when like all these trusts go into like effect and there's any termination. So there's a lot of fun with this. There's some forms in your materials. There's a lot of background in your materials. I'm running out of time, and I know we're pressed for time. I had a blast. Thank you so much, everybody.
All right, thank you, Professor Tritt. Our next speaker today will be Delaney Naumann, who grew up in Dallas, Texas. She graduated from Oklahoma State University, where she received her Bachelor of Science in Economics, and she is a second-year law student here at Tech Law. She will be speaking on her article that will be featured in Volume 10, Book 1 of the EPJ, titled A Woman in Life, but a Man After Death, Protecting the Postmortem Identities of Transgender Individuals. Please help me welcome Delaney to the stage.
Okay, hi. Can everyone hear me? Okay. As Amanda said, I'm Delaney Naumann. I'm a 2L staff editor for the Estate Planning Community Property Law Journal, and I'm here to talk to you today about my comment, A Woman in Life but a Man After Death, Protecting the Postmortem Identities of Transgender Individuals. So several months ago when I was looking for a topic to write my comment on, I had no idea what to pick. And I was looking for something that would be interesting for others to read about, but also for myself to have to write and research about for several months. And I also wanted something obviously that related to estate planning or community property. So after many hours of Googling and not knowing what to write about, I ended up coming across a news article about a transgender woman who had been buried as a man, and it immediately grabbed my attention. So after reading this article, I found out that Jennifer Gable was a middle-aged transgender woman who died suddenly without any sort of estate plan in place. And because she didn't have any plan, control of her body went to Jennifer's father, who chose to bury her as a man. So when the funeral occurred, the guests looked in the open casket and saw that Jennifer had been buried in a suit, and her hair had been cut short, and she was being referred to by her male birth name. And so after reading this, I knew this is what I wanted to write about, because not only was it interesting to me, but I felt that it was important for today's society, because America's transgender population has doubled in size from 700,000 to 1.4 million in the past 5 years. And so because of this, this topic is affecting more people now than ever before. However, it's still a somewhat undeveloped area of the law that I feel deserves attention. So there's two varying state policies that play into how a transgender individual would ensure a proper burial after death. And these two policies are disposition of remains statutes and death certificate recognition of gender identity. Dispositions of remains statutes refers to a statute that governs how a person's final bodily remains are dealt with after their death. And death certificate recognition of gender identity refers to determining what sex is to be listed on a death certificate, which may impact the manner of a transgender individual's burial. So disposition of remains statutes. 49 states across the nation have some type of statute or regulation, but they vary tremendously from state to state. For instance, some statutes require that instructions are to be placed in a will or a prepaid funeral contract. However, this isn't always ideal for transgender individuals because a will might not be found until after the person is buried, and it might not be looked at until then, and so then it becomes irrelevant for the instructions to be placed in a will. Also, a prepaid funeral contract, some people just might not get around to filling one of those out before their death, and so statutes that require instructions to be placed in one of those two areas are not necessarily beneficial for transgender individuals. Other statutes allow family members to make all of the decisions in kind of an order of priority. It's usually something like first to the spouse, then to children, parents, grandparents, etc. And this is also not great for transgender individuals because, like in the Jennifer Gable story, if a person is estranged from his or her family, it might result in an undignified burial. This kind of statutory scheme could also sideline any unmarried partners. If they don't fit the statutory definition of spouse, then they might not be given any control or say in the disposition of the decedent's body. Okay, death certificate recognition of gender identity. In the Jennifer Gable story, the funeral home said that the reason they complied with the father's wishes and ended up dressing Jennifer in a suit was because her birth certificate listed her as a male. And so one way to stop this problem would be if death certificates reflected gender identity, because then funeral homes would no longer be able to rely on this sort of reasoning. The National Center for Transgender Equality went through every state's policies and assigned each state a grade from A+ to an F, depending on their ease of altering identity documents. The A+ states are states that are the most transgender friendly. Their policies are easier, and it's mostly a matter of paperwork to get an identity document changed. However, the F states are ones with very rigorous requirements often requiring serious steps such as surgery in order to alter an identity document. And this sort of scheme hurts people who live in the F states because they are getting unequal treatment and have to spend more time and money to achieve the same results as a person living in, say, an A+ state. Also, many states make no mention of altering a death certificate. It seems to kind of be a little bit of an unprecedented area. Their regulations will talk about altering a birth certificate or a passport or a driver's license. However, they don't really talk about death certificates. And so the closest thing right now to a guide is the Funeral Director's Handbook. And this is very outdated. It hasn't been updated since 2003. And it instructs the person filling out a death certificate to base their decision on anatomy. And this often results in unfavorable consequences for a transgender individual because anatomy is not always the best indicator of gender identity. So I propose that there needs to be uniformity across the states in both disposition of remain statutes and death certificate recognition of gender identity. Ideally, for disposition of remain statutes, personal preference statutes are the best type of statutes for a transgender person. They allow the decedent to designate an agent as well as leave specific instructions for their burial. And because they get to pre-select someone that they trust before their death and leave specific directions, it helps ensure that they will be buried according to their wishes. The Texas statute in Texas Health and Safety Code section 711.002 is actually a good start to base a uniform statute on, because it says that a person may provide written directions for the disposition of the person's remains in a will, a prepaid funeral contract, or a written instrument signed and acknowledged by such person. And the language talking about a written instrument signed by an individual is great in my opinion because it's easier for people to get done during their lifetime. And the statute also provides a sample form for people to fill out, which makes it easier for them to accomplish this before their death. Also, Illinois statute has language that says the directions may include instructions regarding gender identity with instructions relating to appearance, chosen name, and gender pronouns. This is good because it alerts transgender individuals to the type of directions to be included if they choose to take advantage of a disposition statute. And so I believe taking aspects of these statutes would create an ideal statute for transgender individuals. And then I also propose that we make a model uniform law based on the Respect After Death Act, which is a bill passed by California in 2015 that requires that a death certificate be filled out according to gender identity. The bill says that the person completing the death certificate is to determine gender identity through an informant who is likely in the position to know the decedent's wishes. And if there's any conflict between that, then the person filling out the certificate is to look to the decedent's most recent gender identifying documentation to make the decision. And I believe the Respect After Death Act is very beneficial, especially if anyone like Jennifer dies intestate. It can act as a fallback that although they didn't get around to listing specific directions during their lifetime, it will ensure at least they won't be buried as an improper gender. And so I believe all states should adopt a law like this because it ensures compliance with the decedent's wishes. And so to conclude, the transgender community can greatly benefit from uniform laws relating to disposition of remain statutes and death certificate recognition of gender identity. And it's important that all people are buried with dignity, and this is how we can make sure that happens. Thank you.
All right, thank you, Delaney. Before we break for lunch, we are going to have a little drawing here by Southwest Bank.
Hi, my name's Jim Farley with Southwest Bank, and we're tickled to death again to be a sponsor of this program. And so I'm going to let her do the honors. We've got a couple of Bluetooth speakers that we're going to give away right here, and then we've got a couple of things this afternoon as well. Who do we have? No, that's me. They wrote on the back of the card. Anne Marie Caruth. I think she had to leave earlier. Should we have to be present to win? She's a county justice of the peace. I got to be careful here what I say. Whitney Ellis. Is Whitney here? And Christy Hyatt. If y'all come by the southwest table, the speakers are out there. Thank you. I'm not about to tell the end brief.
Thank you. So we are now going to break for lunch, and we will meet back here at 12:40 to get started again. Lunch is already set up at the tables out there. Please feel free to help yourself. There are boxes, and y'all can come back in here and eat. And we'll see you back here at 12:40. Thank you.